When they asked me to speak at the Advanced Trial Skills Seminar coming up in June, and I heard what the subject was, and the subject was dealing with damages in closing argument, I couldn't say yes fast enough. Why? Because I genuinely believe that we face a common enemy in insurance companies who celebrate shortchanging our clients. And I do believe in my heart of hearts that the more we share with each other, the better it is for all of us, and more importantly for our clients. Damages is one of those subjects that's gotten harder and harder. The public eye, the idea of damages, has taken a beating. There's a level of distrust in it. There's a level of people feeling like you're just trying to get some money, as opposed to the concept of trying to replace what has been taken from our clients. So when they asked me to talk to you about damages in closing argument, it touched a spot in my heart, because I think it's probably an area in the law that requires more new ideas and more novel ideas and more invention than any other part of what we do. We can't just rely on the same old arguments that everybody's used for years. Not that they're not wonderful arguments and powerful arguments, but we have to recognize our audience has changed. And we've got to change the arguments with our audience. And I spend so much time as senior trial counsel for Morgan & Morgan in front of juries, I had to learn to do it differently. I had to learn to do it differently to survive out there. And I have learned how to do it differently. And I've developed new models. And I've taken old models and I've reworked them. And the results have told me the changes were well worth it. And what I want to do is take the opportunity to share those and pass those ideas on to the rest of us so that we can all benefit from them. It is one of the most difficult, hard parts of a case, is to do closing arguments and look a jury in the eye and ask for money and do it from your heart and not offend anybody and do it effectively. It's not only, though, one of the hardest parts, it's one of the most fulfilling parts. It's fulfilling because every good trial lawyer I know has what I call the difference maker gene. They all want to feel like I made a difference being there. That the result wouldn't be the same if you just substituted some other lawyer in and gave them the same facts and the same jury. That your words and your presence made a difference. And there's no other part in the case where your words and your presence can make so much of a difference. Because how you present damages isn't in some box that's tied in exclusively to the facts. There's much more latitude. What I want to share with you is models that I know work, that are some of them you have heard from before, but they're going to have a little different flavor. And some of them are going to be brand new. And then I want to talk to you about where, when, and why to make these changes and how to present them, and even some circumstances where you don't even ask for an amount of money. I hope y'all all come, because I really do have some things to share that I think will truly make a difference. I'll see y'all there.